Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Maritime Law, Demise or Bareboat Charterparty, Singapore Maritime Law. A contract, a demise or bareboat charterparty. 1. A contract for the hire of the ship as a chattel. 25.3.9 A demise charterparty is a contract for the hire of the ships as a chattel. The charterer becomes for the purposes of the word at large, except the ship owner himself, the owner of the ship for the durations of the charter. The master and crew are the demise charter's employees. Whether a charter party operates by demise is a question of construction to be determined by reference to the language of the charter party. SGHC 22. The hallmark of a bareboat charter is the transfer of possession and control of the vessel from the owner of possession and control of the vessel from the owner to the charterer. A bareboat charter does not transfer legal or beneficial title in the vessel to the charterer, but because possession and control of the vessel resides in the charterer for the durations of the charter, it is not incorrect to speak of him as having temporary ownership of the vessel or as paying its owner pro hac vice. 2. The charterer operates the vessel for the duration of the charter as he bases subject to any specific restriction in the charter party and pays charter hire periodically. 25.3.10 A demise charterer operates the vessel for the duration of the charter as he pleases, subject to any trading or cargo restrictions specified in the charter party. Like a time charter party, he pays charter hire on a periodic basis. Demise charter parties are sometimes entered into as a form of long-medium-term financing arrangement. Section 4. Carriage of goods by sea. Bills of lading. Bills of lading. 25.4.1 Broadly speaking, a bill of lading is a document signed by the carrier or by the master or other agent on behalf of the carrier, stating that certain specified goods have been shipped on board a particular ship and setting out the term on which the goods would be carried by the ship. A bill of lading serves three functions. It contains of evidence or evidences the contract of carriage, serves as a receipt for the goods carried, and in a document of title. Bill of lading. A. Bill of lading as evidence of the contract. 1. Where goods are shipped by the charter, a bill of lading does not displace the charter party as the contractual document. 25.4.2 Whether a bill of lading is evidence of the contract of carriage depends on whether it is the charterer who holds the bill of lading. Where the goods are shipped by the charterer, the bill of lading does not displace the charter party as the document governing the contractual relationship between the ship owner and the charterer. 2. Where the shipper is not the charterer, the bill of lading evidences the contract of carriage. 25.4.3 Where the shipper or the holder of the bill of lading as a material time is not the charterer, the bill of lading either evidences or contains the contract of carriage. As a general rule, the shipper is entitled to hold the ship owner responsible for his goods and to claim delivery of them on the term of the bill of lading. The ship owner cannot therefore rely on the terms in the charterparty which are not incorporated in the bill of lading. As between the shipper and ship owner, the bill of lading evidences the contract of carriage but may be supplemented or contradicted by any relevant contract that came into existence prior to its issue. However, as between the ship owner and consignee or of the bill of lading, the bill of lading contains the contract of carriage. 3. The terms of a bill lading may be supplemented or superseded by the Hague or Hague Phase B rules. 25.4.4 The terms of the bill of lading may be supplemented or superseded by the provision of the Hague or the Phase B rules. Singapore is a signatory to the Hague Phase B rules, which are reproduced in the Singapore Carriage of Goods Act. The rules have mandatory application on the said act. The applications of this rule is explained below. B. Bill of lading as a receipt. 1. The bill of lading functions as an acknowledgement by the carrier of receipt of specified goods. Fraudulent or negligent misrepresentation may be actionable in tort. 25.4.5 A bill of lading also functions as an acknowledgement by the carrier of the receipt of the goods specified in it. It usually contains various representations as to the quantity and condition of the goods. If fraudulently or negligently made, such representation may form the basis of an action in tort against the carrier by third parties who suffer loss in reliance on them, in particular consignors or financial institution who takes up and pay for the shipping document in circumstances where, if the true fact had been stated, they would have been entitled to reject them. 2. The bill of lading is prima facie evidence of the condition, marks, quantity of good, and date of loading as between the singer, the shipper, and ship owner. 25.4.6 Under the common law, a bill lading is prima facie evidence of the condition, marks, and quantity of the face of the good as well as the date of holding as between the shipper and ship owner. However, as between the ship owner and the consignee or insured, such statement in the bill of lading cannot be reviewed by the ship owner. 25.4.7 Where the bill of lading contains a statement that the goods are shipped in apparent good order and condition, this only amounts to a representation or fact that the goods are shipped in apparent good order and condition insofar as external appearance. This only among the representation of fact that the goods are shipped in apparent good order and condition insofar as external appearance of the good is concerned. 25.4.8 Bills of lading are frequently closed by expressions such as said to contain contours and quantity unknown, and container yard to container yard. The American astronaut, the expression said to be has been held to be ineffective closing of a bill of lading. Through effective closing, the ship owner can negate the statement made in the bill of lading so that in effect no representation can arise from such statement. So the time is up. The video will be continued to the next part, so don't forget to watch the previews and the next part, and bye bye.